Good afternoon, everyone. Welcome to National Whistleblower Appreciation Day. My name is Clayton. I'm an attorney here at Ogborn Man, specializing in the representation of and counseling of whistleblowers and would-be whistleblowers. Today, July 30th, 2018, is very important. It is the anniversary of America's first whistleblower law. And recently, on July 12th, 2018, the Senate passed a unanimous declaration approving today as National Whistleblower Appreciation Day. Now, it is the anniversary of America's first whistleblower law. And so what does that mean? Well, in the 1770s, the Continental Congress passed a law at that time that was really the first recognition of who whistleblowers were, what they contribute, and how they should be protected. In that case, 2 naval officers had reported their commanding officer for abuse of prisoners of war on a revolutionary naval ship. That commanding officer then got them terminated and brought libel charges against them. The Continental Congress voted to provide defense to these naval officers who were retaliated against, and in very strong words reflected exactly what whistleblowers mean to this country. In fact, they resolved that it is the duty of all persons in the service of the United States, as well as all other inhabitants thereof, to give the earliest information to Congress or other proper authority of any misconduct, frauds, or misdemeanors committed by any officers or persons in the service of these states which may come to their knowledge. In other words, placing an affirmative duty on U.S. citizens, as well as others in the country, to report illegal conduct when they come to know of it. And that is really at the essence of what being a whistleblower is. You know, whistleblowers are oftentimes characterized on 2 sides of the coin. One side, they are persons of conscience. They are people who have the courage to stand up, fight for what they believe, and report when they see something that's illegal or fraudulent or unethical. On the other side, oftentimes on the employer or the government side, whistleblowers are often seen as turncoats. They're seen as people who are traitors to the cause. That is part of the perspective. But through my practice and what I know, having represented whistleblowers, is that they're often the sharpest minds in the room. They're the sharp pencil, if you will. They're the person who recognizes problems when they see them, and they have the moral fortitude to raise those concerns, to raise their hand and say, hey, what we're doing isn't right. And they're oftentimes the impetus for change, not only within corporations, but also throughout society. Now, this today, like I said, July 30th, is National Whistleblower Appreciation Day. So in celebration of that day, I wanted to go through a few of the recent whistleblower issues and cases that have come up in the news and have made a big impact. Likely the most important of these is the recent Digital Realty v. Summers decision by the U.S. Supreme Court. That decision dealt with the Dodd-Frank Act and its anti-retaliation provision under its provisions, which are broadly positioned as whistleblower provisions. So under the Dodd-Frank Act, it has 2 whistleblower provisions. One is a bounty provision, under which a whistleblower can submit information to the SEC regarding a violation of securities statutes, and if the SEC is able to successfully prosecute based upon that information, the whistleblower might be entitled to a certain percentage of what the SEC recovers. The second provision is an anti-retaliation provision, and that's what was at issue in the Digital Realty case. In that case, the Supreme Court looked at the anti-retaliation provision, which says that, quote, whistleblowers shall not be retaliated against for engaging in various protected activity. Well, the term whistleblowers within the Dodd-Frank Act, that statutory provision, had a specific definition above. The SEC later promulgated regulations that said that the definition of whistleblower under the anti-retaliation provision was different from the bounty provision. In other words, that in order to qualify for anti-retaliation protection, a whistleblower did not need to report information to the SEC. So at issue in Digital Realty was that conflict between the SEC rules and, frankly, the plain language of the statute. And somewhat predictably, the Supreme Court found that it was the plain language of the statute that controlled. In other words, now, post-digital realty, in order to be protected by the anti-retaliation provisions of the Dodd-Frank Act, a whistleblower must first, prior to any adverse action being taken against them, report their concerns regarding breaches of securities laws to the SEC. And they have to do so by a specific process that involves sending a specific form to the SEC. So that is a prerequisite now to bringing a Dodd-Frank anti-retaliation claim. The Dodd-Frank anti-retaliation provision is actually much broader than protecting just that activity. In other words, in particular, it incorporates the Sarbanes-Oxley Act. And so by incorporating the Sarbanes-Oxley Act, it incorporates things like reporting wire fraud, mail fraud, fraud on shareholders. The thing now, post-digital realty, is that in order for that conduct, reporting those violations, to be protected under the Dodd-Frank Act, the whistleblower must first report that information to the SEC prior to any adverse action being taken against them. So that is an unfortunate restriction of the protections of the Dodd-Frank Act. Now, the digital realty case was announced in February of 2018. One day later, here in the 10th Circuit, where I'm standing in Colorado, and in a case that I was proud to work on, the 10th Circuit handed down the Genberg v. Porter decision, which was a Sarbanes-Oxley whistleblower case. In that decision, the court adopted the more whistleblower-friendly provision of a reasonable belief standard for protected activity. So now, within the 10th Circuit, a whistleblower, in order to engage in protected activity under the Sarbanes-Oxley Act, need only have a reasonable belief that what they're reporting constitutes a violation of one of the enumerated statutes under Section 1514A, which is the Sarbanes-Oxley Act anti-retaliation provision. Previously, under prior ARB case law, whistleblowers had been required to, in their report, definitively and specifically relate what their reported concerns were to one of the enumerated statutory or regulatory provisions under SOX. Now it's simply just a reasonable belief standard, which is a much more whistleblower-friendly provision. Further, the Genberg v. Porter case went on to also note how whistleblower-friendly the causation standard is under SOX. Under SOX, a whistleblower need only prove that their protected activity was a contributing factor in the adverse action that was taken against them. And this is a relatively low standard. Courts have held that as long as protected activity is one out of many other reasons for an adverse action, that standard is satisfied. So you could have 99 reasons, and as long as one of them is the protected activity, then the standard is satisfied. In Genberg v. Porter, the 10th Circuit found that that causation standard could not be cut off by a legitimate intervening event, meaning a legitimate intervening reason for the adverse action, when the protected activity was inextricably intertwined with the investigation that purportedly resulted in that legitimate intervening event. So for instance, if a whistleblower engages in protected activity, and because of that protected activity an investigation is started, and as a result of that investigation the whistleblower is terminated, the protected activity, the investigation, and the eventual termination are all inextricably intertwined with each other. And a defendant employer cannot cut off causation by simply saying that the investigation provided a legitimate reason for the termination. And another significant portion of the Genberg v. Porter decision is that it seems to indicate that the burden shift under the Air 21 statute, which is specifically incorporated into the Sarbanes-Oxley Act, that there's a defense under that statute that is called the same action defense. It essentially allows a defendant to escape liability if they can show by clear and convincing evidence that they would have taken the same action even in the absence of the protected activity. And what the Genberg decision seems to hold is that that is an affirmative defense that can be waived or forfeited if not pled or if specifically declined in the pleadings, which could significantly increase protections for whistleblowers. Now, both of these decisions, both the Digital Realty decision from the Supreme Court and the Genberg Reporter decision out of the 10th Circuit, have significant effects. The Digital Realty decision, obviously from the Supreme Court, governs all courts in the United States. What that decision did, like I discussed, is requires reporting to the SEC before you're able to be protected by the anti-retaliation provisions of the Dodd-Frank Act. And what that really does is create an incentive for whistleblowers to report out, to report to the SEC, which is a concern that a lot of publicly traded companies had when the Dodd-Frank anti-retaliation provisions and bounty provisions came up. They were concerned that there was going to be a lot of reporting to the SEC of all sorts of violations of security statute. Well, that didn't really come to pass, but now, in order for a whistleblower to be protected from adverse employment action, they have to report to the SEC. So it's really forcing a lot of would-be whistleblowers who would otherwise report internally only to go external to the SEC in order to receive the enhanced damages and the enhanced protections of the Dodd-Frank Act. So, funny enough, what this Digital Realty decision may have really done is increase the incentive for whistleblowers to blow the whistle externally, as well as internally. Whereas before, they felt that they had protection if they only reported internally. The Genberg Reporter decision, although much more localized as it's only a 10th Circuit decision, really has the impact of furthering the reasonable belief standard for Sarbanes-Oxley whistleblowers. That standard, like we discussed, is a much more whistleblower-friendly standard than the prior Platone standard, which was a definitively and specifically standard. So now, there's much lower threshold for whistleblowers to cross in order to show that they engaged in protected activity. There are a couple other things to talk about here as far as prospective or looking into the future. There's a couple of cases coming down the pipe and a couple of issues that might pique whistleblowers, would-be whistleblowers, and attorneys' curiosity. One of those is the Biorad case. Wadler v. Biorad was a case out of I believe it was the Northern District of California, which is now up on appeal to the 9th Circuit. In that case, a general counsel for the company Biorad had engaged in protected activity and asserted claims under the Sarbanes-Oxley Act, the Dodd-Frank Act, and various state law claims as well. One of the big issues in that case was whether or not this general counsel could use attorney-client privileged communications to prove his claim. The trial court in that case eventually found that in fact the general counsel could use such privileged and confidential communications and information to prove a whistleblower retaliation claim, which was a big victory for in-house counsel whistleblowers. In fact, the court found that the SEC rules that require in-house counsel to report certain conduct up the chain actually preempted any ban that the California ethical rules may have imposed on in-house counsel as whistleblowers. So it was a really big victory there. Eventually that case went to trial and resulted in a multi-million-dollar verdict for this in-house whistleblower. Up on appeal now is several issues. The most important of which is probably whether or not the court properly allowed privileged and otherwise confidential information to be used by the whistleblower to prove his retaliation claim. Now, there is some precedent from the 9th Circuit. The Van Asdale case will certainly be cited and will certainly be probably determinative in this case. In that case, the court did allow attorney-client privileged information to be used by in-house counsel to prove a Sarbanes-Oxley whistleblower claim. The ARB has also made a similar decision in the Jordan v. Sprint Nextel case. Another issue that's interesting is whether or not reporting of harassment based upon sexual orientation will be protected activity under Title VII. currently there's a circuit split. The Second Circuit and the Seventh Circuit versus the 11th Circuit. The Second Circuit and the Seventh Circuit have both held that discrimination based upon sexual orientation is discrimination because of sex under Title VII and is therefore banned by that statute, whereas the 11th Circuit has held the opposite. The issue for would-be whistleblowers, people who are thinking about reporting either discrimination or harassment, is whether or not that will be extended and how the Supreme Court would rule on this circuit split. If Title VII is interpreted to protect individuals from discrimination based upon their sexual orientation, in that any such discrimination would be because of sex, well then individuals who report concerns regarding such discrimination or report harassment because of sexual orientation would also be protected from retaliation. And so it would significantly broaden the individuals who are protected from retaliation under Title VII. Now, this concludes our talk today about whistleblowers. Thank you for joining me. Again, please celebrate National Whistleblower Appreciation Day. Please go to our website for more information. That's www.whistleblower-attorney.com. We would love for you to visit the website, find out more about the protections that are afforded to whistleblowers, and contact me especially if you have any further questions or need any more information. Also, as you're celebrating Whistleblower Appreciation Day, please don't forget to use the hashtag #ILoveWhistleblowers in order to report on whistleblower issues and thank whistleblowers for what they've done. Thank you for your time today, and happy National Whistleblower Appreciation Day.